Okay, so hello and welcome to Legal Circle. Thank you for joining us today. We have enough participants at the moment, so we're just going to start without further delay. And then as participants join us, they can feel free to listen in. And hopefully what we'll be doing today is keeping the question and answers to the very end. I will first be speaking today on the employment and employment updates, and then we'll have Richard Brady speak about Force Majeure. I might start without further ado. Okay, so who we are, just a quick summary of who we are. We are legal specialists with a strong reputation for being agile, nimble, and passionate. And I like to think very fierce in our commitment to finding practical, legal, and commercial solutions. We practice adaptive, innovative, and cost-effective legal solutions, and we do this so that we're able to produce offerings that are bespoke and cost-effective for businesses, whether it's a startup, a small, medium enterprise, or a multinational corporation. So today it'll be myself and Richard Brady. For those of you who have not met us before, there's a picture of the both of us, and you can obviously see us live as well. All right, so let us commence. What I wanted to note was this is actually a second part 2 webinar on employment. We did have a webinar, employment webinar, part 1, I think a week or 2 ago. So today we won't be covering everything in detail that we covered on the first occasion. Today we're going to look at what we haven't covered, and in particular the updates in respect to a few free zones, namely DIFC and DMCC. I will recap though on the most important provisions, which are the Ministerial Resolutions 279 of 2020 concerning the employment stability in the private sector. So probably most of you already know this, but for the benefit of people who don't, I'll quickly recap. So Article 2 in that ministerial resolution looked at employers and the ability to not unilaterally, but mutually agree, mutually agree by express written agreement any of the following options with their employees. So the option is remote working, secondly, paid leave, thirdly, unpaid leave, fourthly is temporary reduction of salary, and fifth, permanent reduction of salary. So in the ministerial resolution, they have these in those orders, and what we think is that the resolution envisages that the measures are taken in that order. So you start with remote working and then go on to paid leave, unpaid, and 4 and 5. We do understand from the Ministry of Labour, though, that parties can mutually agree on on one of those provisions without having to resort to them in the order that they're in, but it has to again be mutual agreement. So now just a quick update on 23 April 2020, Dubai government released guidance and protocols as it transitions to reopening. So what we're seeing at the moment, which is different from a couple of weeks ago where there was a complete lockdown, the government has come out with the guidance and protocols. So at the moment, the company's occupancies in office spaces is 30%, and there is still 70% that are required to work from home. So 30% is the ceiling, and there are common areas within the office spaces. So you have to ensure that there are no high-risk individuals present at work. The office hours, building and office hours cannot exceed 8 hours daily, and there cannot be more than 5 people in a meeting. And of course, no gatherings permitted. So at this stage, although we've seen a relaxation of the rules, there is still a need to be very aware and cautious of the remote working provisions and the guidance and protocols as they relate to office and companies and specific industries. Today, though, we won't go into specific industries and the different guidance and protocols on those. We'll leave that for another webinar. We'll specifically focus on employment. So if we look at the next, the second option under the ministerial resolution of paid annual leave, Essentially, this follows the Federal Law number 8 of 1980, which says in Article 75 that employees are entitled to an annual leave of 2 days per month if they've completed 6 months or more, and 30 days if they've completed 1 year of service. And the calculation of duration of annual leave will include official holidays specified by law or by agreement, and any of the leaves caused by sickness if they fall within the annual leave. So this article is from the existing laws. It wasn't amended by the ministerial laws at all. The reason why I'm mentioning it here is that as a second provision, paid annual leave, this is still what you would need to follow. Article 76 also mentions that employers may fix the date of commencement of annual leave and, if necessary, divide leaves into 1 or 2 more periods. So this is what we see a number of companies doing. They are following the guidance and the order of the ministerial resolution. And when they are relying on paid annual leave, they're choosing to separate the periods into 2 periods and choosing when those periods can apply. So if we look at unpaid leave, again, if you're choosing or you've chosen to provide unpaid leave to your employees, one of the things that you need to know is that unpaid leave is not included in calculating the period of service. So when you are calculating, unpaid leave relates to gratuity or impacts on gratuity at the end of a period of service that an employee has been with you. So if you've given unpaid leave during this COVID time, what you need to be aware of is any unpaid leave that you have given is not included as part of period of service. So when you're calculating gratuity, it will be on the period of time minus the unpaid leave dates. And I've put in the provision there about gratuity. So a worker who has completed a period of 1 or more years shall be considered to be in continuous service and entitled to severance pay. And the service pay shall be calculated as follows: 21 days for each year of the first 5 years and 30 days for each additional year. So I can take questions at the end of this. For the moment, I'll just mention that. Okay, so temporary salary reduction. So under the ministerial resolution, it does allow for temporary salary reduction. And that particular provision says that the salary reduction will continue to apply until the addendum or expiry date, or until such time that the precautionary measures have been lifted, whichever comes first. So generally, if you are going to be reducing the salary for your staff, we recommend that you have a period of time in the addendum or in a contract. If you're not going to be relying and using the Ministry of Labour addendum, you would still need to document it in an addendum or an additional contract. And we recommend to include the period of time. So if the precautionary measures or the government decides that now we are no longer affected by COVID-19, and that happens earlier than the date you've specified in your agreement, then that date prevails and the period of time expires. So if you are going to reduce your staff's salary, you should have 3 copies of the addendum. So one for the employer, one for the employee, and to keep one in case the ministry requests this. So it's not a requirement to lodge this with the Ministry of Labour, but it is a requirement to get a 3rd copy in the event that they require one. So the last provision or option for employers is the permanent reduction. So permanent reduction requires mutual consent by the employer and employee, but it also requires approval by the Ministry of Labour. And so they may ask you about how and why it is, or how you've been affected, and ask you to produce proof to ensure that the measure you're taking is one that is necessitated by the circumstances and not, I guess, an abuse of the situation and taking advantage of the COVID-19 period. So what we see is the government's doing a great job of really trying to balance out the employer and employees' rights and being fair to the both. So if we look at the second point is that employers cannot take drastic measures, or what we can see is that the government's at least encouraging them not to take drastic measures from the outset and go straight to a permanent reduction. They'd like to see reasonable and gradual steps and an exhaustion of all the possible alternatives and measures that can be taken before exiting an employee or terminating or reducing permanently their salary. So it is a note to be aware of and to consider when you are looking at, corporate restructuring and employment restructuring within the organisation. Nobody's barred from or immune from, I guess, court proceedings. So you may run the risk of legal proceedings if you don't support your actions and decisions that you've taken with the right documentation. Okay, so another leave, which is, we know employers are allowed to provide, is early leave. So if the employee wishes to return to their home country for the period of time that we're under COVID, that is also a possibility. They would need to sign an additional supplementary form for the employment contract. That's again available on the Ministry app and website. It's the employer's responsibility to book a flight ticket and return for the worker. And it's very important to note that the contractual relationship between the employer and the worker continues, and early leave is considered unpaid leave, with the worker retaining the remaining entitlements prescribed for him under the law. So nothing changes there if an employee agrees to take early leave and returns to their home country. The contractual relationship between the employer and employee remains. So the worker's early leave ends upon his return and starts work after the precautionary procedure period. So we'll just take a quick look at sick leave. I mean, we didn't in the last one, so I thought it might be a good idea to cover it again because we had questions around this. So there are no provisions of sick leave in the ministerial resolution, so nothing there changes, and we rely on the article in the UAE laws, Federal Law number 8, relating to sick leave. So no sick leave is due during a probation. Once the employee has passed probation period and worked continuously for a period of 3 months, then he or she is allowed 90 days leave per year, consecutive and non-consecutive, and entitled pay for the leave is as follows. So 15 days with full pay. Following that, there is 30 days with half pay, and then following periods without pay. So if you have anyone in your workplace that has been affected by the coronavirus and has taken sick leave, this provision still applies to them. So we'll just take a look at now gratuity and how that's calculated. So in the circumstances where an employee's salary is temporarily reduced, gratuity is still calculated on the previous basic salary. So what we need to keep in mind if you are an employer is that the provisions and the options that the government has provided for are temporary. So unless you're permanently reducing or unless you have terminated, the options are temporary, and the entitlements that an employee is entitled remain, and they are under the laws, under the UAE employment laws. If so, on the second point is if an employee's salary is permanently reduced, then the gratuity at the end of his service will be calculated on the new basic salary. But if we're not looking at permanent reduction, then the gratuity remains the same, calculation remains the same. In terms of allowances, housing allowance and medical insurance is payable by the employer who's sponsoring the employee. So this again doesn't change, and it doesn't change particularly where there's a temporary change to staffing, and I'll go to that in just a minute when we speak about the virtual labour site. But before talking about that, I'll just cover termination. So under the UAE labour law, provisions apply. under the UAE labour law, provisions apply to termination and not ministerial resolution, because the ministerial resolution has actually remained silent on this topic. So the threshold remains the same in terms of, if you are going to be considering terminating an employee, it needs to be for a valid reason. So under the laws, and if we look at previous court judgments and the way they were decided, a valid reason is a work-related reason. Now, what we do understand from our discussions with the Ministry of Labour, and what we also, just following the laws, that we are in quite unprecedented times, and the courts have not yet dealt with a situation like this before. So there is no way of really knowing or advising somebody and saying how the courts will look at this. But what we do think is that the courts will take a compassionate approach to both the employers and employees, and be very reasonable when they are making a determination about termination in particular, and whether it was called for and justified by the employer. So if you are an employer, it's very, very important to make sure that you've documented all your discussions with the employees, that this is a decision that you're really exercising as a final option rather than the first option, unless, for example, you've had discussions with employees and they've agreed to this option, or that they've agreed to, or that they've not agreed to any other option, and it's forced you into the position of terminating an employee. But I can say, certainly from our experience and the discussions we've had with clients so far, employers and employees have been quite reasonable in the approach that they're taking to this situation. So hopefully we don't have too many disputes between employers and employees. But from an employer perspective, there will be a need to prove the decision and to justify that, if that is one of the options that you've resorted to immediately. So keep all the documents, and definitely you will need to show and prove that there was difficulty if you did use that option immediately. So if you do terminate, need to keep in mind that an employer is still required to pay all the dues in accordance with the laws, such as the leave and gratuity payments. So if we just have a look now at free zones, because so far the ministerial resolution and all the options that we've just discussed are applied to the mainland. In free zones, it's a little bit different, although they're not necessarily obliged to follow the resolutions. We see that most of them are, except for Difc very recently with their presidential directive number 4 of 2020, only about a week ago, has deviated a little from the ministerial resolution. So if you are in the Difc, and we'll go through those in a moment, what the presidential directives are, and also the DMCC have an additional guideline number 1 of 2020, again, which follows and is very similar to the mainland resolution. However, there is a minor difference that you should be aware of. So if we look at the Difc now in closer detail, so the directive was issued on the 21st of April 2020 with immediate effect, and will stay in effect up to and including 31st of July 2020, which they refer to as the COVID-19 emergency period. So insofar as may be required to facilitate the implementation of the directive, the presidential directives will supersede the other relevant provisions in the law number 2 of 2019. So we just look now at the emergency employment measure. So employers, quite different and distinctive from the mainland. In the Difc, employers may actually impose one or more of the following employment measures in respect of their employees. So they can impose a reduction in the working hours, vacation leave, leave without pay, temporary reduction in remuneration, workplace access restriction, and remote working conditions, including remote working requirements. So an employer wishing to apply any of the above measures can do so without the prior consent of the affected employee. It's unlike the mainland, where you cannot do this unilaterally. The Difc have moved a little bit away from that and allow an employer much more room to make, I guess, decisions that they feel they might need to during this period of time. The employer, though, is required to give 5 days prior notice in writing to the employee for any one of those measures that it decides to take. So if we look at the sick leave, this is a little bit different also from the mainland. Sick leave taken by an employee during the COVID emergency period as a consequence of having contracted corona, for being placed in quarantine, shall not count towards sick leave entitlement of the employee under the Article 34, which is the DIFC law number 2. So there is this, they've actually moved away from their own law in relation to sick leave and put in place this particular and very, I wouldn't say peculiar, but specific sick leave under the circumstances. So employees shall be entitled to 100% of their daily wage for the duration of the sick leave and may not be subject to any of the above emergency employment measures if those measures were not imposed on them prior to taking sick leave. So we see here that they're trying to treat any employees that have contracted corona very fairly and leniently, and I guess give them the maximum opportunity to make use of sick leave during this time. And if you've not imposed any of the restrictional measures before they were sick, then they're not applicable, which is quite interesting. So if we look at the DIFC Presidential Directive number 4, again, in relation to visa and permits of terminated employees, again, they've tried to be lenient and treat employees with some fairness during these times. So during the emergency period, employers may defer the cancellation of residency visas provided the employer continues to provide the basic medical insurance and accommodation. So this again is in line with the mainland and resolution. So where the terminated employee is dependent on the employer for accommodation until the cancellation of terminated employee visas, the employer is obligated to maintain medical insurance and accommodation. But no other core benefits or rights shall accrue in favour of the terminated employees who remain on an employer sponsorship during that period. I guess one of the things that we can see from the DIFC directives is they're quite articulated very clearly, and they leave no room for interpretation, which is a little bit different from the ministerial resolution. So it's very clear here in terms of how visa and permits and terminated employees are going to be treated. So another, I guess, a benefit to employees is the employee database that the DIFC has, which is similar to, again, what the mainland has in terms of the virtual labour market. The DIFC has an available employee database, which the surplus of employees can go on to put themselves potentially out to other employers. An interesting thing is this database may also be shared with other competent authorities that are maintaining a virtual labour market, really, I guess, to be fair to employees and give them exposure to a wider jurisdiction and area other than the DIFC. So that's quite an interesting and positive move there for employees. So if you look at the gratuity payment, again, the DIFC has covered this quite clearly. So the end of service gratuity payment will not be affected by the directive gratuity payments during COVID-19 for all employees. So what the DIFC directive says is the employees will be calculated by reference to employees' basic wage, and they've specified 29th of February as the date. So any employee after that date that is affected, the gratuity payment will not be adversely affected. So any shortfall of gratuity payment by an employer who terminated an employee subsequent to the 1st of March prior to the issuance of directive will need to rectify their calculation and make that payment as a shortfall to the employee. So the DMCC, interestingly, one of the free zones that as well has not completely deviated from the ministerial Ministerial resolutions and the mainland, but it has put the order and the options available to employees in a little bit of a different order. So we can see that firstly, there's the remote working, which I think is across the board, all free zones and mainland. Secondly is paid leave. They've swapped around 3 and 4. So the third option is temporary reduction of salary before an unpaid leave option is provided to the employee. And again, the DMCC has the view that the options are applied gradually in the order on the slide. So if we look at the visa matters, this is going back to just mainland. So if you are a mainland company, we get a lot of questions around visa matters and how work permits and visas are treated. At this stage, we've seen no change by the government in terms of work permits and medical tests for visa renewals for the private sector. So there's still a waiver in that regard. Again, the expired UAE residency of entry permits and residency visas who have expired can remain valid until the end of 2020. So the validity is automatically extended until December 31st, 2020. Again, there won't be any delay or fines for expats who can't stamp their visas or get their Emirates IDs processed or obtain medical insurance due to the COVID situation. So authorities are working on a mechanism that will enable expats to return to their home countries, but we've not yet had any major announcements in that regard. What you do need to be aware of is if you do hire somebody who's on a visit visa, you can still change the status. And if you are hiring a temp employee, you need to obtain a letter and an NOC from their employer. Okay, so the key practical steps, really just to summarize what we've covered today, is that you cannot decide on any measures unilaterally unless you were inside of the DIFC free zone and you have employment contracts in the DIFC. Otherwise, it is not a unilateral decision that an employer can make, and it needs to be a discussion between both employer and employee. So generally across the entitlements, they remain more or less the same under the labour laws. So when we look at the gratuity, the leave rights, sick leave and termination for unrelated COVID reasons, unpaid leave is not included in calculating the period of service. So we've already covered that in the previous slide. Be sure to document your communication in writing. So whilst I don't want to present this as doom and gloom, but we anticipate that there will be disputes between employers and employees. So really to safeguard your interest and in order to satisfy the court in the event of a dispute, if there is one, everything should be documented in writing. And if you're based in a free zone outside of the DIC or DMCC that we've covered today, we more or less, they have stayed in line with the mainland, but it's always positive and to contact that free zone or speak with the lawyers. We're definitely more than happy to help you to look at the particular free zone you're in and what nuances there might be in that free zone in order to avoid any disputes. One thing to keep in mind though is that in the event of a dispute, most of the free zones, if not all of them except for the DIFC, will revert back to and be heard by Dubai courts. So we understand and assume that Dubai courts will follow and uphold best practice as it is in the mainland resolutions. Another point to remember is that you cannot contract out of entitlements provided by law, for example, annual leave or medical insurance. So, for example, we've had a number of clients ask if they can reduce the annual leave that's entitled by an employee. That's not the case. So the annual leave and the amount of annual leave an employee is entitled to is in the laws, as we covered in the earlier slide, and you cannot agree and reduce that or force and impose any employee to reduce any of the annual leave. So this is one thing to keep in mind. I believe that's the end of my discussion. I didn't see that I covered, and I believe it must have been just an error that we didn't cover the virtual labour market, but most people probably already know this, and it was covered in the previous webinar about the virtual labour market. So if you do have a surplus of employees, they can go onto the virtual labour market, where another employer from another company can, for a short period of time, take over that employee. And so the obligation then on the new employer will be to pay the salary, but the obligation on the previous employer will remain that he will need to cover housing allowance and the medical insurance. So I may have just accidentally skipped that. I'm just verbally mentioning that at the moment. If you have any questions, please write those in the chat box and we'll cover them at the end of this. So that's the end of my presentation today. So just a little bit on how we can help. At the moment, there are a lot of, obviously, not disputes, but I guess questions by managers and CEOs and GMs about what they can do in terms of restructuring the employments and contracts. So we can help you deal and negotiate with those. If you're looking at workforce downsizing, corporate restructuring, we can do a complete overhaul and a legal health check on all of the contracts within the company. So not just from an employment perspective, that whether there's any, if you're in supply chain, any of your supply chain contracts. There are a lot of companies who have cross-jurisdictional issues, given that, for example, they're bringing produce, or if they're in being supplied from overseas, so what's happening on that front and how that's been affected, and then liaising with any regulatory authorities to support you in discussions with them to gain or to have advantage of any of the options and the benefits that a lot of the authorities have at the minute during the COVID-19 period. So that's all from me at the moment. I'm going to hand you over to Richard Brady, who's going to be looking at force majeure and whether Corona and COVID-19 can fall within that to terminate your obligations under a contract. Without further ado, I'll pass you over to Richard. Please, if you've got any questions on the topic I've just covered, you can feel free to add those in the chat box and we'll have a look at those at the end of this webinar. So Richard, hand it over to you.
Thank you very much, Suraya. I wonder if we can go to the first slide on force majeure. Well, basically, it's a terrible mess, isn't it? And the problem is, because we haven't had time yet to see what the courts think of the different arguments that are put before them, we're all rather in the dark with regard to the interpretation of the strict rules of the law regarding force majeure and frustration. Obviously, it's causing an effect on the global economy. Huge impact on supply chain. And although one company may not be affected by force majeure, the supply chain suppliers may be stopped from supplying them because of force majeure circumstances. We've seen the aviation industry and the travel industry take a huge knock. Hospitality has basically closed. Insurance is racing to change their insurance policies to exclude COVID-19 from health risks. The construction industry is in a very strange position because on the one hand, building sites are still running, but again, suppliers may not be able to supply the materials, and that itself would be a force majeure situation. In real estate, we're seeing huge drops in the sale prices of properties, and with employment, well, as you've just heard from Suraya, there's a vast number of rules and regulations rapidly being introduced, which we're all having to get used to. So if we could move on, in fact, to look at force majeure itself. Thank you. Well, the starting point, if I can just go back to the last slide, if I can give you one general tip with regard to difficulties you might find yourself in, wondering whether or not it's force majeure and wondering whether or not and how it's going to affect you, I would say communicate. Talk to the people on the other side of the contract. at the very least, you will avoid falling foul of Section 246 of the Civil Code of the UAE, which implies an obligation to act in good faith. If you keep silent and you don't tell the other person what you're doing, how can you be said to be acting in good faith? So under the UAE law, the Civil Code, law number 5 of 1985, that gives a definition of force majeure. We're going to look at that in a moment. It may be, however, that your contract is governed by the common law court of the DIFC, the Dubai International Financial Center. This has a slightly different approach to force majeure, and it may well be that you could also possibly rely on the common law doctrine of frustration of contract, which is similar to but different from force majeure. And then again, you've got the ADGM. This again is a common law court, and like the DIFC, there'll be some differences between the way in which they interpret force majeure from the UAE Civil Law Code, and you might be able to achieve the high bar of showing there's been frustration of contract. Well, first of all, let's look at the DIFC principle of force majeure, okay? As I said, this is governed by Article 82, or sorry, I should say, this is governed by Article 82 of the DIFC contract law. This is law number 6 of 2004, and it implies a force majeure term, a force majeure clause to excuse non-performance if the non-performance is due to an impediment beyond a party's control and, of course, was not reasonably foreseeable at the time of the contract. Right, now let's just do a 1 point straight away. Force majeure is an existing problem. If you're entering into any contracts now, you can't say, oh, I want to claim force majeure because of the COVID-19 situation. You can't. It's already foreseeable right now. So you can't use it for new contracts entered into at this stage. Probably you can't use it as a defense to any contract entered into after March 11, which is when the World Health Organization said it was a global pandemic. And quite possibly, you can't use it as a defense to any contract entered into after 31st December 2019, when the World Health Organization first started issuing its warnings about COVID-19. Right, let's move on. Okay. Now, force majeure effects can impact on a contract in a lot of different ways. Sometimes they make the contract completely impossible. In others, they merely delay performance. The staff can't get to work to complete the construction because they can't cross the border. Well, when the lockdown terminates, they will be able to cross the border. So they will be able to terminate the contract. So force majeure under the common law idea can allow temporary suspension of a contract rather than pure termination. Whereas in the UAE, it terminates the contract or that part of the contract which is affected by it. Now, the one thing force majeure doesn't allow you to do is to say it's a force majeure situation, therefore I don't have to pay you. Obligations to pay are not affected by force majeure. Now, as I mentioned before, obey all the notice requirements. If you want to claim force majeure, and it's mentioned in the contract, then undoubtedly there'll be a provision in the contract relating to the notices you must give to the other side. And not merely claiming force majeure, but you must also say how it affected you and what steps you're taking to get around the problem and when the problem will cease. And you may even be required under the terms of your own contract to prove that you're taking these steps to get round the problem. Now, failure to give notice in a reasonable time may not allow you to claim force majeure. In construction contracts, you've usually got 14 days, and this is very strictly interpreted. The contracts are in English. It's meant to be easily understandable. If it says you must give notice in 14 days and you don't, then the court can't help you because you didn't bother to do what the contract said. And it's also very important with force majeure that you try to mitigate the extent of non-performance by taking reasonable steps. Now, as we looked at with regard to employment, that could include working from home to complete the paperwork side of the business. It could include getting somebody else to finish off part of the contract where the employees, your employees, can't cross the border. Maybe there's a local supplier of employees that could finish it for you. Right, let's move on from that to the next point. Thank you. Now, the UAE Civil Code, as I say, it's Federal Law number 5 of 1985, sets the definition and boundaries of a force majeure event and the consequences that it triggers. So, in principle, Article 273, which is very important in relation to this situation, Article 273 of the UAE Civil Code stipulates that in order for an event to qualify as force majeure, it must be first claimed in a bilateral agreement. In other words, a contract between two parties. And, unlike the civil law, like the common law courts, it makes the performance of the obligation impossible, not just more difficult or suspends it or makes it not cost effective, it makes it impossible. Just because the contract now is no longer economically viable doesn't mean it's force majeure. You must be physically impossible of performing the contract. That was the way force majeure came into being right back in the old Roman days. And it's the way the French incorporated it into the Napoleonic Code back in the 19th century. It's got to be completely impossible. Right, let's move on from that, please. So, as I said, Article 273 of the Civil Code is very important. Under subsection 1, if the force majeure makes the performance impossible, then all the contract obligations cease. Not are suspended, they cease. The contract's automatically cancelled. However, under subsection 2, if only part of the obligations becomes impossible, then just that part of the contract is extinguished and the rest of the contract will continue. Now, when this occurs, this subsection gives you a choice. It permits the party who has to perform the action to either cancel the entire contract on giving notice to the party who was expecting to receive the benefit, or just to cancel that part that's now impossible. If you cancel the whole contract under 273 subsection 1 or subsection 2, then this really is to be treated like rescission under a common law contract. The contract is unwound, unpicked. The parties are put back in the position they were in before they entered into the contract. Of course, that's not always possible. Goods delivered might have been consumed. Money provided might have been spent. If that's the situation, then the party that loses out can be compensated and must be compensated by damages by the party that's cancelling the contract. That way, the party that suffers a loss gets compensated even though the contract is now terminated. Let's move on to the next slide, if we could, please. So, force majeure can be established on the grounds of either a physical situation, earthquake, or a legal or statutory legislative impossibility. For example, natural disasters, change of law by the government, perhaps expropriation of land for public interest by the government, making a contract cease. Epidemics like Ebola are clearly force majeure, and COVID-19 is clearly a force majeure situation. But just because it's force majeure in many situations doesn't mean it's automatically force majeure for your contract. Every contract has to be looked at on an individual basis. The written contract is really the instruction manual for the deal. And the first place you should go to see what your obligations are and how you can terminate, and if you can terminate, and what you must do if you do terminate. They'll all be in the contract. Now, just let me stress, mere hardship or uneconomic balance because it's no longer possible for you to make a profit out of the contract, that's not force majeure, even if it's the COVID-19 that's caused this situation. However, under the Uae Civil Code, there's a get out. Under provision 249, the courts in the UAE, provided the case is put before them, have the power to reduce the obligations imposed on the parties. In other words, they can take a fresh look at what would be fair in all the circumstances and then impose those lesser obligations instead. In many ways, this reminds me of the old common law idea of equity, but this is the UAE putting it into a statutory code. So provision 249 may be very useful when companies come to try and reassess their obligations. Right, let's move on and we'll quickly head to some questions. Now look, we received some questions and the situation has become a little clearer in the last 3 or 4 weeks with government regulations being put in place, etc. Let's have a look at this first question we received. A hotel cancelled the musicians' performances 10 days before the government officially cancelled all live entertainment in venues in Dubai. The event was cancelled because the number of guests for the event had reduced, making it uneconomic to hold it. Why had they reduced? Well, even though the government had put the laws in place, they'd been making radio announcements telling people not to go out. There were still a few guests, but if they ran the event, it wouldn't be economically viable. Well, initially my thinking on this was, well, they're making it difficult to make a profit, but they haven't made it impossible. But on thinking further, what you're doing here is if you do try and run this event, you're running it contrary to public policy, because it can't be the public policy of the UAE that if the government says you shouldn't do something, you should still encourage people to do it anyway by advertising. So I would say in this case, it's not so much COVID-19 that's the cause of the force majeure situation. What's allowing you to stop this contract and not honor it is the fact it's now contrary to public policy. And any contract which is for an illegal purpose or a purpose which is contrary to public policy is invalid. Would this be considered force majeure? It's a moot point. But I think it's not really a question about force majeure. It's whether or not a contract like this, which is contrary to public policy, should be allowed to go ahead anyway. Let's move on to the next question, please. Well, I've mentioned Article 249 of the Civil Code, giving the courts wide discretionary powers to reset the obligations. Now, again, I think this is going to be very useful, but don't forget the obligation under Article 246 to serve a notice on the other party to tell them what you're doing, because that way you can not be charged with breaching your articles of good faith. Tell the other side what you're going to do, tell them why you're doing it, tell them what steps you're taking to avoid the problem, tell them what results you've had, explain why you're having to do what you're doing. That's good faith. Okay, let's move on. Now, Article 287 is a get out for those contracts which don't have force majeure clause in them. Article 247 of the Civil Code provides that if a person can prove that a loss arose from an outside cause in which it played absolutely no part, it will not be obliged to make good the loss suffered by the other person. Now, Article 249 states If the exceptional, unforeseeable circumstances make the performance of the contract very difficult, but not impossible, then the judge has a discretion to reduce the obligation to a reasonable level if it is fair. Doesn't result in the termination of the contract. Contract continues, but you don't have to do as much as you did before. Now, the one big problem, of course, is the Civil Code doesn't define what is force majeure. But I think we all understand that COVID-19 is force majeure. Whether some of the other situations it causes are force majeure is another point. Where the contract is silent, the court will decide using the Civil Code, and so Article 249 would come into play along with Article 287 and Articles 273, 1 and 2. Right, let's move on. So we received some other questions. I'm going to assume this was from a shop owner who said, we've started incurring massive losses. Are we covered by insurance clause, B1 cover? Well, the problem is I don't know which insurance policy you're talking about, so I can't really tell you. But if you took out the insurance policy way before the COVID-19 started, and it covers business losses, then you may well be covered. But without seeing the policy, that's like a doctor giving a diagnosis without examining the patient. I can't really answer without seeing your contract. What happened here was that they leased a shop 3 months ago and had 2 months to fit it out. They hadn't been able to start the interior work because of approvals being delayed by the authorities. Well, that's not COVID-19. Then the shutdown occurred. Well, that is COVID-19. Are we liable to pay rentals which start this month? Well, possibly. If the contract is governed by the common law jurisdictions, you might be able to pray and in aid the provisions of I've forgotten my own wording. So I beg your pardon. You might be able to pray and aid the provisions of frustration of contract. Frustration of contract occurs when something happens completely unexpected, which destroys the economic basis of why you wanted to make the contract. Now, why would you want to enter into a contract to lease a shop? Well, you'd probably want to display goods there and sell them to the public. And if, because of the lockdown, people were prevented from entering the shopping mall where your shop was, then the purpose of the contract, showing your goods and selling them to customers, has been frustrated. But again, that will only apply if it's a common law contract. Look at question number 4. What's the best way out for those who have individual owners as opposed to landlords? Well, it's to talk to them. Landlords are business people. They won't want you to go out of business, so they've got no tenants when the COVID-19 situation finishes. So communicate, like I said at the beginning. The key to dealing with all of this is communication and good faith. Let the other parties know what you're doing and let them know as quickly as possible. Don't hope it goes away and nobody will notice. It won't go away. And even if it did, I can tell you now, the legal problem will come back. And when it does come back, it will be twice as bad as it is now. Deal with it. It's the only way to move forward. Well, thank you very much, Suraya. That's plenty from me, I think, on this subject. Shall we see if there are any questions? I think that's enough. Yeah. Thank you, Suraya. Do you want to unmute yourself?
Sorry about that. I was going to say we can cover some points on the construction claims under FIDIC.
Oh, sure. Right, well, of course, construction claims. Now you're in a very strange situation here. 3 or 4 weeks ago, it was suggested that as young people are the people who are employed on building sites, and as COVID-19 won't be as serious for them as it will be for older people, therefore, COVID-19 was not force majeure in terms of the building industry. I understand that argument, but I'll bet the suppliers who supply materials to the building sites, I'll bet they've given their employees, wherever possible, time off work, and because of that, they may not be able to bring the supplies in. And being short of supplies on a construction site, that would be force majeure if you're short of supplies through somebody else's fault. Now, with FIDIC contracts, force majeure isn't defined to include specifically epidemics, but it's understood that it can include it. But with FIDIC claims, with FIDIC contracts, you don't automatically terminate the contract if it's a force majeure situation. First, you look at postponing performance until the force majeure situation terminates. If the performance is postponed for 6 months, then either party can terminate the contract. But I have the feeling that force majeure is going to be over and done before the 6-month period is reached. So in many cases, you're going to be looking at suspension of performance, so you should be given extra time to complete construction of the buildings. Right, thank you very much. Let's see if we've got some questions, shall we?
I'll just unmute myself. Okay. So what I might just quickly do is cover if the checklist. So if you are based in the UAE and you do have a contract that you're potentially looking at whether, you know, the situation of COVID can apply, what do you do? Where do you begin? So you always start by reading what the contract says, checking the governing law of the contract, because you know, if there's anything that we hope we've demonstrated in this webinar, it's that the governing law of the contract does affect how what the contract says and how the courts will look at deciding it. So read the force majeure and termination clause to see if the circumstances are included. Check that the circumstances actually affecting performance. So there needs to be a causal link, as Richard explained. You need to check the notices section to see who, how, when, and where notices is to be served and what is to be included in them. So what steps are to be taken and proof of taking them. So you need to also check that the performance is actually impossible and not merely difficult or just expensive, or it's just a case of, you know, you don't want to pay because at the moment there's a cash flow issue. You need to check that the performance is, check what steps can be taken to mitigate or minimize the financial harm and ensure they're taken. So for example, if there's a delayed delivery or if there's or sell elsewhere, you need to check your insurance coverage. So a lot of the clients that have been reaching out to us have insurances and, you know, need to know and understand how they're covered under those insurance. So it's really important to look at the insurance coverage separately from the contract and see how together they can be addressed, or how the full picture that they give. So keep in contact with the other party, negotiate, inform, and try to mediate. Don't try and win an argument, particularly not now. So what we advise our clients, particularly who are doing business, is that this time will pass. So although things are difficult at the moment, you want to be able to keep those relationships with your business partners after the COVID-19. And so the best way to do that is really to negotiate, inform, and to mediate where possible. And we can definitely support you with that if necessary. So you can consider the hardship relief provided under Article 249 of the Civil Code in the UAE. And I believe Richard has already covered that in enough detail. But if you have any questions, please feel free to ask. And for some contracts, parties are entitled to payment for the work completed and expenses incurred up to the value that the counterparty has already benefited. So just to keep that in mind. Okay, so FIDIC contracts do operate a little bit differently, as they will allow for suspension of performance without discharge of the contract. Okay, so that covers pretty much the employment topic and the force majeure topic for today. I've already gone through how we can help you during these times. Please do follow us for, sorry, that's my cat just walked across the screen. Please don't mind her. Oh, sorry. please do follow us on social media, all the sites. So we're keeping up to date on all of the topics, and we will also have, moving forward, some interesting topics. We're looking at post-corona, so not only talking about what's happening at the moment and the changes in the law, which practically everybody is covering right now, but please do keep following us on LinkedIn. Check out our website. We've got lots of social media pages as well, Facebook and Twitter, for our upcoming webinars, which are going to be very, very insightful and look at post-corona, if I can put it that way, and what industries are going to really survive and come out of it too. So if you're looking at that, we do have online support packages for the corona crisis where we have very reduced fees, and we're also going to be initiating some different packages, so keep your eye out on the corona crisis support hub for those, for more affordable fees for legal. That way you get to ask us unlimited questions for a very limited fee. So at the moment, I can see that we have a number of questions that have come through our chat. So I'll just read those aloud and answer those for the benefit of all the participants. So the first one is whether annual leave can be substituted with cash if an employer is unable to release the employee in a year. So what I assume or understand that this question is asking is that this particular employer cannot afford at the moment, during these times, perhaps they're quite busy, allow the employee to take the annual leave. So that needs to be agreed between both parties. The employer, if he does agree not to take annual leave, then yes, cash should be and can be paid in lieu of the leaves of the unavailed days. So hopefully that answers that question. Another person asked whether they can terminate staff under probation. Yes, you can terminate staff under probation period. Generally, the probation period is about 6 months, or it might be reduced. So please look at the contract to see what the period is. And if you are terminating within that, then that's absolutely lawful. But if it's gone beyond the probation period, then everything we've covered in the webinar applies. Will this pose an issue with WPS? So at the moment, what we've seen is that the Ministry of Labour and their systems, such as the WPS, are on top of matters, and it shouldn't at this stage pose an issue. If it does, please come back to us and ask us some questions to we can support you on that. But at the moment, I don't see any issues on that front. For unpaid leave, what is the entitlement considered as? So unpaid leave is where you're going to allow an employee, or if they've agreed, to take leave without pay. So for the days that they've taken leave without pay, or if it's been for the full month, then they're not entitled to their salary. But in terms of all the other entitlements, they remain. So gratuity remains at 21 days for for working beyond 1 year. Their leave entitlements in terms of their annual leave days again remains the same. That's not reduced just because they've taken unpaid leave. The only thing is that the unpaid leave comes out of the days when you are calculating gratuity, which we explained as well in the webinar. So I hope that answers the question. So I can see here is mobile allowance also to be considered. So when we're looking at allowances, it's important to realize that there is a difference between allowances and salaries. So a salary is made up of a basic salary plus other allowances, and as a total, it's looked at the salary. So when you're reducing that, you're reducing the total salary. So I'm not sure what your arrangement is with the employee and how and what whether part of the salary is a mobile allowance. But what I would say at this stage is that for anything that is not completely necessary, and for what the laws haven't specified, for example, you've got medical insurance and housing accommodation, they're the main allowances we see that cannot be taken away from an employee, particularly during the COVID situation. But mobile allowance, for example, may, and previously we've been asked whether you can reduce, for example, fuel and a fuel allowance, or if the employee is not traveling and that particular allowance is outside of the salary, then that can potentially be reduced. So I hope I've answered that question. So they're pretty much all the questions we've had today. Richard, there hasn't been anything specific about force majeure. Unless somebody has any further questions, that's all for today. There will be a pop-up survey at the end of this webinar. If I can ask everybody who's remained with us, and I can see that most of the participants have, which is great, if you can please fill in the survey and let us know what you'd like to hear more on, because we would love to stay relevant and make sure that we're answering the questions that the business community really needs right now. So please answer the survey. Tell us what you'd like to hear more about. Follow us on LinkedIn for our upcoming webinars. You've got the details on the page. Please take those. Contact us if you need to. We look forward to seeing you at the next webinars. Thank you very much for your time, and take care.
You're very welcome.